Hello, everyone, and welcome to a new session with the Rights and Responsibilities Awareness Initiative. We are lucky again to have Rebekah Ryersee, licensed paralegal with a good standing with the Law Society of Ontario, to talk to us about a very important and stressful issue for so many people. Eviction notice under the Ontario Residential Tenancies Act. Thank you, Rebekah, for being here with us today.
Oh, thank you so much, Ethan, for that wonderful introduction. I'm very happy to be here. For everyone, my name is Rebekah, and I'm a licensed paralegal in Ontario. My practice focuses on small claims matters, provincial offenses, and landlord-tenant issues. Today's presentation is part 2 of a series of 3 on the landlord-tenant board. And it's about evictions, the scary evictions. We have provided a copy of this presentation materials, or we will at least at the end, so that you can refer back to any websites, links that I have, and follow along if need be. So I'm just going to quickly share my screen. We do have a little presentation to show you. And there we go. So please be advised this presentation is for informational purposes only and should not be considered legal advice. But if you have further questions or require legal advice, please contact a paralegal or a legal clinic in your area. So topics we're going to cover today are: why is an eviction notice issued? What do you do when you get a notice? Your rights and responsibilities. And then we'll go through some next steps and some questions. So let's begin, shall we? Sorry, I do still have a cough. You have to question whether or not your rental falls under the Residential Tenancies Act. So if you are in a roommate situation or a shared accommodation, that's not covered. And also, if you are in a, well, that's shared accommodation if you share a kitchen and bath, condos, trailer parks, commercial properties, they won't be considered, or they won't be in this presentation at all. They have a certain set of rules that they need to follow, and they're not covered. So what does the Landlord-Tenant Board do? Well, it's a tribunal overseeing all the landlord-tenant issues. The issues are brought to the board through applications. The files are considered by an adjudicator and through a tribunal hearing. A tribunal hearing, though it's less formal than a courtroom, there is still a specific process. The proper forms are to be filled out accurately. The parties present their case at the hearing, and then the adjudicator, they hear it and they review the information and they make a ruling or a decision on the issue. This is considered a binding judgment. The Residential Tenancies Act is the law, the rules that not only landlords and tenants need to follow, but also what the adjudicator would refer to for the law. I've also included the website address, the email address, and the phone number for the Landlord-Tenant Board anytime that you need to contact them. So notices need to be served properly in order for the document to prove that you can prove that the document was served in a timely manner and to the correct person. Everything needs to be accurate because you don't want to get to a hearing date and find out that the whole thing gets thrown out. So if you do want to see more on navigating the portal on the LTB, please do ensure that you stop by for part 3 of our series. So why would a landlord need to evict a tenant? That's a question I hear all the time. I'm going to show you a few things. These are just 3 of the eviction notices that you can receive. So an N4 is a notice to end your tenancy early for non-payment of rent. This is a very common one. If you get behind in arrears, the day that your rent becomes due, the day after they can issue an N4. So it's not a month later, it could be the exact day after. And the landlord serves the tenant the N4 to put them on notice. So there's a deadline that the tenant must either pay the arrears in full or leave the apartment, the unit, and the total amount owing needs to be listed on that N4. Those are two very important things. So we'll get into this more later, but let's just say you don't agree. I don't owe $5,000, I owe $50. Well, that's a disagreement, and you have every right as a tenant to disagree with it. If the tenant, for example, says, well, there's maintenance issues, and if you were here for the first part of our series, we went through all the maintenance issues that we could possibly think of. Things like who changes the furnace filters? I have a broken window. My door doesn't work. Those are maintenance issues. So you might say, well, and I don't recommend you do this at all. It's actually against the rules. But if you said, I'm not going to pay my rent this month to see if I get my landlord to pay attention, oh, you'll get his attention, all right. But at the same time, you're not doing what you should be doing as well. So again, maintenance issues, we've already gone over those, but we'll get into those a little bit deeper today. So if another common notice is an N5, notice to end your tenancy. Maybe you've done damage. You're doing something illegal. Maybe you have overcrowding, or you're being a nuisance. If you're loud and rambunctious, you've got dogs running around. Those are going to be common reasons to be issued an N5. But the third that I've listed here is an N12. These were not common 20 years ago. They are very common now. And what does an N12 mean? It's a notice that the landlord requires the unit to be vacant. That means he needs to evict you. And my apologies, they can choose many different options. One could be, they could be selling the property, and the new purchaser, the person that wants to move in, they're going to be taking it as their own personal residence. They could be bringing Yaya and Papa from the old country, and that's their property. So they're going to give Yaya and Papa that house to live in. There are rules that they have to follow, and I do suggest that you look them up if you receive them. But the N12 is different from other notices because it's based upon something called good faith. That means that you are trusting what they say is true, and their intentions are to be believed. So if they indicate that the new purchaser is to move in, you have to take it on good faith that that is true. If you do not believe that it's not in good faith, there are other options that you could follow. One is to wait for a hearing, or you could file what they call a T5, which is generally after you move out and you did so on good faith. So the landlord owns the property that the tenant's renting. You have to consider that that's not only his property, it's his investment, right? And if they need the property vacated, it's their right to ask for an eviction. Tenants also have the right to question it and the validity of an N12. They must compensate you for 1 month's rent. Their intention is to occupy the premises for a minimum of 12 months. They're going to be occupying it within a reasonable amount of time, and the parties listed are the ones that are going to be doing the occupying. So he can't check off that it's going to be him moving in, and then he brings in his nephew's uncle's cousin's best friend from wherever to come move in. He marked it as his own personal use, then it needs to be him. And he has to move in within a reasonable amount of time. So these notices also need to be served properly in order to document that they were received in a prompt manner. For example, They can't just post it to your door. They have to do what they call a certificate of service. They can hire a paralegal, and the paralegal ensures that the service is done properly, because you are being notified that you have to pack up and move, and you need to have enough time to be able to do so. So what do you do if you get a notice? Don't panic. It's the first thing that you're going to do. You're going to start, sweating. What do I do? I'm being evicted. I want you to relax, because only the landlord-tenant board can evict you. Understand that. Just because you have a notice in front of you doesn't mean that you're going to be evicted. So I want you to read the notice and the instructions. And what you would do is go to the landlord-tenant board site. You're going to click on forms. You're going to find the eviction notice that the landlord gave you, and you're going to click on instructions. The instructions are the rules that the landlord has to follow. If you read that, that gives you education. Now you know where he's coming from, what he is required to do. You know the time limit, and deadlines are very important. So the notice indicates why it was issued, but the instructions have to be followed, because any mistakes, and this could avoid the notice. You might disagree with the notice, but it's very important that you take the eviction notice seriously. So I'm just going to briefly go over a couple questions here. Let me move myself out of the way. What if I feel like the notice is in retaliation? So let's just say, as an example, you had been complaining to the landlord. There's maintenance issues. The window doesn't shut properly. The door doesn't work properly. You've made these complaints to the landlord and you're being ignored. Then suddenly the landlord comes up with, I need you evicted. I'm giving you an N12. You got 90 days to get out. And you think, yeah, you're only doing this because I complained. Well, there's recourses to follow. I'm not going to get into too many details about them now, but I might answer them later on in the presentation. There's several mistakes on the form. Do I just ignore it? This always goes back to, it depends. What type of mistake? Did they get the unit wrong? Did they get the actual address wrong? Did they get your name wrong? Is it only in your name, but you and your husband live there? These are all things that you might want to look into. Remember I said about those instructions? What if the landlord knocks on your door and says, I want you to sign this? I'm going to tell you right now, do not. You have every right as a tenant. You have every right as a Canadian citizen to look at the form, take a look, and take your time to read over this. So if they're trying to get you to sign it at the door, they're putting you under pressure. Just say, I'm going to keep this. I'm going to read over, and I'll let you know if I'm going to sign it later. If you need somebody else to read it over or a paralegal to review it, please do so, because do not sign anything unless you know what you're signing. Even if you agree with part of it, you don't need to sign it. What if I'm in arrears? Something happened. I lost my job. I was in the hospital. I didn't get a paycheck that week. What do you do? Because now you are actually in arrears. The best thing that you can do is to contact your landlord and say, I realize you had to send me an N4, but I have a payment plan. Because usually the process is a very long one. There's a cost to it. There's fees associated. So maybe the landlord be willing if you came up with a certain plan of how you would repay it. Now you do need to follow through with this plan. So make sure it works within your budget. Don't go more than 30, 40, 50% of your income to pay it back. So you can stretch it out, but come up with a plan and see if the landlord is willing to work with you. In that situation, if you get to a hearing, the adjudicator would see that you laid a foundation of trying to fix the problem. So what was the last thing? We talked about retaliation. How about if the notice does not apply to you at all? This came up in maintenance issues. If the notice is an N5 because you have dogs barking and you say to the landlord, I don't own any dogs. It might be, say, a neighbor. It might be the person that lives behind you over the fence. If the notice does not apply to you, I usually suggest that you immediately contact the landlord and you say, you've got the wrong person. And this is why, because if you were to get in front of an adjudicator and there was nothing said, your silence might be construed as acquiescence. Basically, essentially, it's, well, you agreed with it because you didn't argue back. Another thing is, always get them in writing. So as much as I do like speaking to people, I'm here, it's best to have it recorded. So if you could send an email, text message, Facebook message, send a letter, whatever you need to do so that you have it in writing, that you put the landlord on notice that you do not agree with the eviction notice and why. Just going to move another slide. Excuse me for a second. Let's talk about your rights and responsibilities. Now, the landlord has rights. You have a right to seek legal advice, and that's strongly recommended. You and other tenants, so if your landlord lives in the building or upstairs from you, you have a right to reasonable enjoyment, to not be harassed or disturbed. And this is an N5. This is the notice you would send your tenants. If the tenant owes you arrears, you can serve them an N4. The N4 to terminate the tenancy or collect the money owed. Rent is to be paid on time in full by the due date, usually the first of the month. And if that's happening where it seems a tenant is not paying on time and it's, later in the month, you need to serve an N8. We didn't discuss that today, but you can look it up. Now, if the landlord, like I said, needs the property for your own use, that's where an N12 comes in. The landlord is to make sure that everybody in the building has reasonable enjoyment. Reasonable enjoyment isn't, what can we use an example? Providing a pool in the hot summer months. Reasonable enjoyment is they don't need to be harassed. They don't need to hear loud music, stomping in an upstairs unit, things like that. The landlord is actually responsible to make sure that everybody in the unit, everybody in the whole building has reasonable enjoyment. And that's a decision that they have to make as to how far does it go. They need to record every time it happens, every time they receive a complaint, so that they can issue it to the tenant. Now, as for tenants, you have a right to seek legal counsel. Do not sign any documents right away. Keep copies of all the documents. Take pictures. You can use your phone. You could simply download an app. There's Adobe, which is a scanner. Scan the document, take a look at it, especially if the landlord wants to walk away with it. It is your right to do so because you were asked to sign something. You need to be able to read it over or have somebody else look over it. You have a right to go to a hearing and present your defense, present your case. I don't have dogs, or I've paid my arrears. You have a right to do that. And if you have any concerns about maintenance, you can file an application of your own, and the two of them will be heard at the same time. So everything gets dealt with in the same hearing, and you don't have to come back. If you agree that you do owe arrears, you should pay them out by the termination date. If you do so, the landlord cannot apply for the board to evict you, because it basically makes the N4 void. Sorry, my cough is really bad today. Now, you also must maintain cleanliness of the unit. We discussed that before. Cleanliness is ordinary cleanliness. What would a reasonable person consider clean? And you have to have respect towards the other tenants. All right. I think that's about all I have. I don't have any other questions that I've listed here, but what I've done in the presentation that we will provide to you is next steps. So there's going to be a deadline. If you do not meet that deadline, it's going to move to a hearing. The parties must ensure the deadlines are accurate and they are met, because remember what I said, the day after a deadline is when action can happen. The application at the landlord-tenant board will happen. Statutory holidays are not included. Refer to the form, instructions, and corresponding rules. So there's two parts of it: the landlord-tenant board website and the RTA, or Residential Tenancies Act. Both of these are put together for the rules and the forms that you use and the procedures. So I'm just going to get out of this screen right now. And remember, like I said, we are going to put that into the comments. I made a mistake by not providing it to Heatham just as of yet, but we will make sure to do that. Do we have any questions, Heatham?
Thank you, Rebecca. Actually, yes, we do have some questions. One, what if my landlord refuse the payment plan?
Well, then he's going to have to go to a hearing. The most important thing you did was you tried. You made an effort to mitigate, to negotiate a resolution before you got to a hearing. That will be considered a weighty thing when you get there. What's going to happen? It depends. If you have made payments, just continue to make your regular monthly payment. Make sure that you're paying off the arrears. And here's an example. I've heard that landlords have sent the money back or refused the e-transfer. Again, document everything that you've tried to make it amends. I'm trying to fix this. But if they don't want the payment plan, maybe it's because it's extended too long. Landlords might not want to wait 12 months to get paid. So if that doesn't work, maybe go back again, try a different one. And if they downright refuse, okay, we're going to have to go before the board.
So should I represent myself in front of the board in any eviction hearing, or do you recommend using a professional service?
I am absolutely going to recommend a professional service. I've got a couple options for you. So if you go to a paralegal, and like me, this is what I deal with every day. It's not just about knowing the law, it's knowing how to do the research. People like me in this profession also do 1-hour consultations, because maybe you just want to do it on your own. And here in Ontario, they have, it's not a law, but it's sort of like a mandate that everyone has a right to access to justice. And what that means is you have a right to represent yourself. So the board, the LTB, makes those forms very clear so that you should be able to follow them, fill them out yourself. If you go to a hearing, you should be able to represent yourself. Because remember what I said, it's not as formal as a courtroom. The adjudicator knows that you're there on your own. They will ask you questions that maybe need to be answered. They will understand that you maybe are a little nervous about it. So do we recommend you get professional legal advice? Yes, I do. Even if it's just an hours of a consultation. I do recommend, even if you've brought yourself all the way to that point and now you have a hearing date, you might need just a paralegal to do just that one portion. And I get that a lot because I can ask the right questions at the right time. I know when to present evidence. I know when to question about dates and times and money owed. I'm able to look through your evidence and look through the evidence from the other side and be able to decipher what we need to bring up. Or maybe I found a mistake. Maybe I can catch somebody, and I being careful with what I say, but some people do tend to lie. And maybe I can catch that on the stand and win you your case. But it is also open to do it on your own. You're free to do so. And it is common to see that happen.
Do I have to pay any fees for the landlord and tenant board if I got a hearing as a tenant?
If you start the application, yes, there's a fee. If they started the application, you just show up to the hearing. So if you remember back when I said, you owe the landlord maybe rent arrears, but you think that they're doing it because you've asked for things to be fixed around your apartment. So you kind of feel they're in retaliation. They pay for the N4, you would have to pay for the T6. Tenants are a lot less of a fee. I think it's $53 or $58, where landlord is like $150 to almost $200 to do an application. That's why you have to take eviction notice seriously. So if you are just going to a hearing about an application the landlord made, no, there's no fees involved. Okay, not with the board at least. If you are doing your own application, yes, there's a minimal fee.
So last but not least, and please, for the people who are following and watching us on the social media platforms, please feel free to type your questions in the comments so we can ask them to our presenters. So last but not least, do you think that the board might consider any personal circumstances for not paying the rent on time?
Yes, absolutely. I've seen it happen. So, for example, you go in there and say, I'm so sorry. I got behind because I was in the hospital or my child was sick. I wasn't able to work. Yes, absolutely. That's your defense. That's the reason why you got behind, and that's what you present to the hearing at the hearing. So if your defense is a legitimate one, it can't be, unfortunately, I'm so sorry, I didn't work this month because I went on vacation. No, you still need to pay your rent. Another thing would be an N12. Your defense would be, I don't believe that this is in good faith. I think that they just want to put it on the market again because my rent is well below market rent and they're going to kick me out to put it up really high. That could be your defense. Again, you need to show evidence. But yes, you definitely could bring that up as a defense. And I suggest that you do.
By all means. So taking into consideration that seems that there's no more questions, at least up to, let me see if I may just take a look to the other platforms. I just would like to let our audience know that this session will be available into our social media platforms, our YouTube Twitter, Facebook, and LinkedIn. So if there is any other questions, feel free to comment on the links, and if there is anything we can ask on your behalf, we will do so. So at the end of this wonderful presentation, Rebekah, I would like to express my serious thanks, RRAI thanks to you for your time and effort in spreading awareness to this great community, to help us feel more people welcome and safe into that community, to reduce the level of stress, because I know it's a very stressful notice. You might get the eviction one. It's taking into consideration the high amounts of rent currently and the inflation and all the hard economic hardship for everyone. So I'm pretty sure it's pretty tough one. So thank you very much for enlightening us today. It's an honor to have you with us.
Not a problem. And I'm just sending that presentation to you. I don't know if you're going to put it in the comments or not, but everything that we talked about, all the links, websites, phone numbers, I've just sent that to you now, Ethan.
Well, do so by all means. Thank you very much.
You're welcome. Thank you.
You are welcome. Have a great rest of your day.
You too. Bye now.